In this video, we are going to discuss about Memorandum of Association, without which a company cannot be incorporated. It gives the particulars of a company. Section 2, subsection 56 of Companies Act 2013 describes memorandum as it is a document which is originally framed and altered from time to time. Can be defined as determines powers and objects of company, scope of activities. It is called a primary document to which MOA must be subordinate. It gives the information about fundamental conditions on basis of which the company got incorporated. It is a public document which helps in mobilizing huge funds from the public. It is a charter and constitution of company. Purpose of MOA. It serves two purposes towards shareholders. While making the investment, they will be interested in risk and return on it. Towards outsiders and creditors, while entering into work-related contracts, they will be interested in scope of activities. Features of MOA. Once MOA is prepared, it should be printed, drafted into paragraphs, serially numbered, stamped and registered with ROC, signed by subscribers to the memorandum in the presence of minimum 2 witnesses. Contents of MOA. It has 5 contents, namely name clause, object clause, domicile clause, capital clause and liability clause. Whereas in case of name clause, in case of public, private, section 8 and OPC companies, it shall mention limited, private limited, neither limited or private limited, one-person company in their names. Name allotted shall not be desirable in any case, like it should not be similar to an existing company's name, it should not use trademark or logo of an existing company, and the words used shall not be given in Names and Emblems Act. Once the name is allotted, shall be printed on the office wall and printed on the stationery items like common seal, etc. In the object clause, it defines the main objects of company and the incidental objects. In the domicile clause, name and state of which the company got incorporated shall be mentioned. Whereas in case of liability clause, liability of members according to the nature of company must be mentioned. In case of capital clause, the amount by which the company got incorporated and classification of capital is required to be mentioned. Alteration of MOA. While coming to alteration, in case of name clause, if central government or regional director is of the opinion that the name allotted is identical or similar to an existing company, it may give directions to change the name within 12 months from the date of incorporation, and the change shall be made in 3 months from such direction. Whereas in case the company used the trademark or logo of an existing company and within 3 years of incorporation, the owner of trademark or logo has made an application to central government or regional director, it may direct to change the name and trademark within 6 months from such directions. The procedure is to hold a board meeting, pass a board resolution and discussions for change in name. Apply for new name with ROC in INC 1 with prescribed fees, convene EGMs, pass special resolution, file MGT 14 with ROC within 15 days. Make an application to ROC in INC 24 for the changes along with notice and explanatory statement. ROC shall issue a new certificate of incorporation in INC 25. The change shall be effected on each and every copy of MOA and AOA, common seal and stationery items. Stock exchange should be informed, newspaper advertisement to be given, statutory authorities to be informed. Alteration of domicile clause. We have 4 cases, where in case 1, changing of office from one place to another place in the same city within the same ROC. The procedure is board meeting, board resolution is to be passed, and there should be a discussions for shifting of office from one place to another place. File INC 22 with ROC within 15 days of passing resolution. In case of case 2, changing the office from one city to another city under same ROC. Procedure is held a board meeting, pass board resolution and discussions for shifting of office from one city to another city, pass EGM special resolution, file MGT 14 with ROC within 15 days. An explanatory statement should be filed with ROC. File INC 22 with ROC within 30 days. In case of listed companies, special resolution should be passed through postal ballot system. In case of case 3, changing of office from one ROC to another ROC, that means in case if there are two ROCs in the same state, it is generally happened in Mumbai and Tamil Nadu, where there are two ROCs in each state. Procedure is board meeting is to be held, pass a board resolution, and should be discussions, and there should be a discussions for change. Pass EGM special resolution, file MGT 14 with ROC, file INC 22 with ROC within 30 days. In case of listed company, special resolution is to be passed through postal ballot system. File an application with RD in INC 23 for permission of change, but before filing, at least 1 month before, company shall issue a public notice in English and in newspaper, that is in local and English newspapers. Serve the notice to each and every debenture holder and creditor for inviting their objections within 21 days. If no objections are received, it will be assumed that all of them has given their consent. RD shall confirm the order within 30 days from the date of application. Company shall file confirmation order with ROC within 60 days from the date of receipt of confirmation order in INC 28. The registrar shall register the change within 30 days from the date of filing confirmation order and shall issue conclusive certificate for this effect. In the last case, changing the office from one state to another state, that is from one regional director to another regional director, the procedure is to be held a board meeting, pass a board resolution and discussions for changing. File EGM is to be held, pass a special resolution, file MGT 14 with ROC, file INC 22 with ROC within 30 days. In case of listed company, special resolution is to be passed through postal ballot system. File INC 23 with RD along with the fees and following documents: copy of MOA and AOA, notice of shareholders meeting, minutes of meeting, list of debenture holders and creditors entitled to objections, an affidavit for the above list, board resolution and power of attorney. The list of debenture holders shall not be older than 1 month, along with the names, address and amount outstanding. An affidavit of correctness of list of creditors and debenture holders must be filed and to be signed by company secretary, if any, and minimum 2 directors, of whom one should be a managing director, the signing authority. An affidavit regarding the number of employees to be retrenched due to shifting of office must be filed. The acknowledgement of all the documents and returns must be filed with Chief Secretary of the State Government and Union Territory. All these documents must be kept in a safe custody and open for inspection. At least 14 days before, the company shall issue a public notice in local and English newspapers and serve the notice to each and every debenture holder and creditor for inviting their objections. If no objection is received, it will be assumed that the consent is already given. RD must pass the confirmation order within 60 days. This order must be filed with both ROCs within a period of 30 days in INC 28. The new ROC shall register the change and give the certificate to this effect. Stationery items will be changed, stock exchange to be informed, and statutory authorities also to be informed. Thank you.